you're negative, I will remove the no contact order. But if you're going to be positive with an illegal substance, then there's going to be a no contact order because obviously CPS didn't do their work. There's going to be a $1,500 fine that will be probated. 3 years deferred adjudication. This is run concurrent with 2025 CR 007562C. Is that a motion to revoke?
No,
Can I have parties announced?
Rick Pena for the state of Texas.
Suzanne Kramer for Mr. Aguirre.
And are you Mr. Aguirre?
Yes, ma'am.
All right, so this was recalled back for sentencing because the court wanted the CPS worker here, and the state informed the court that they were unable to have the CPS worker here. So both parties had no objection to the court reviewing the CPS records. Is that correct, state and defense?
Yes, that's correct.
Yes, Judge.
Okay. And so outside the agreement, the state was requesting no contact with the complainant. And my understanding, defense, you were opposed to that.
Back then, yes, I was, as I am now.
All right. So state, you're asking for no contact, and I will tell you, the court's concerns was that drugs were being grown in the child's room.
Yes, Your Honor.
All right. And from reading the CPS records, it's the court's understanding that the child does go to school. Is that correct?
Yes, Judge.
Yes.
Yes.
All right. Do you want to raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do, Your Honor.
You can lower your hand, state your name for the.
Guado?
All right. If you're tested today, what would the result be? And let me just tell you before you answer me. If you're negative, I will remove the no contact order. But if you're going to be positive with an illegal substance, then there's going to be a no contact order because obviously CPS didn't do their work. So if you're drug tested today, what are the results going to be?
I take methadone on a regular basis.
Okay.
That's in my system. I have quit smoking. I knew though it took like 2 months last time for when I was in CPS to get clean. It's been over a month since.
So here's the thing. See, this is the problem. And this is, I understand that CPS can only keep their cases for a year and they say, oh, people are doing okay, it appears, so we're just going to dismiss this case. That case has been dismissed for a while. You should not have gone back to using marijuana. And I'm assuming when you say in your system, that's marijuana?
Yes, Your Honor.
All right. And the person, your wife, has she been using marijuana as well?
No, no.
Will she be positive?
Whoa, pause right there. The judge is basically saying if you fail this drug test, say goodbye to seeing your kid. That's a massive emotional bombshell in any custody fight. What do you think? Should one positive test completely cut off parental rights, or should there be more chances for rehab? Drop your thoughts below.
No, Your Honor.
All right. So here, this is what I want you to understand. Part of my job is to make sure that children are protected, make sure the community are protected when they're placed on probation. All right. Methadone. I understand that people use methadone. In my personal opinion, methadone is just another drug, but I understand why it's prescribed, but those levels should be going down. But you should not be testing positive for marijuana. Marijuana is not a part of the methadone recovery system.
Yes, Your Honor.
So why should I allow him to have contact when he's still using marijuana? Or at least live in the home since he's still using marijuana?
Well, I was unaware that he was still using.
Judge, I was as well with all of my conversations with him, where obviously marijuana was the issue. He did not inform me that several months ago he used it. I can say that what happened in court at the last setting scared him greatly in terms of having to move out of the house and not being able to be around his children. I've watched the interaction with him, and at least the small one, Layla, is very good. I don't think he will be using it anymore. And of course, I have no problem with the court zero tolerancing him on weekly marijuana urine testing just to make sure that he's complying. I don't think he will. I think he got really scared at the last setting that he needs to get his act together and has not had any since then.
All right. So here's my question for you. Do you have parents in the city?
I have a father here.
All right. Is that appropriate place to stay?
Yes, Your Honor.
All right, so this is what I'm going to order. He's going to live with his father, not live in that home until he's negative for marijuana. You know,
And then as soon as he's negative, he can go back.
when he's negative, they can come back to the court and ask that he be allowed to live in the home. So here's the thing. Your attorney was fighting so hard for you and you didn't do your part. So don't blame her. She did her part. You didn't do your part.
Of course.
Your part was to come into court to be negative, present something to me because you knew the state was asking for no contact. You knew I had concerns because drugs were being grown inside your child's room. You understand?
I do, Your Honor.
All right. This is what the court is going to do. Are you employed?
I am, Your Honor.
And what do you do?
Packing for Pure Flavor.
All right. There's going to be a $1,500 fine that will be probated. 3 years deferred adjudication. This is run concurrent with 2025 CR 007562C. Is that a motion to revoke?
No,
Now here's the twist. The judge just revealed this case ties back to another major drug charge. So we're not talking about a single mistake, folks. This is a full-on history. And look at that frustration from the bench. You can almost feel the disappointment. Question for you. If you were the judge, would you trust him back in that house anytime soon?
that's the main case, actually, Judge.
Yes, that's the initial drug charge, CTD drug case.
So the 2025 CR 009798, is that the case we're proceeding on?
We're proceeding on both, Your Honor. They're running concurrently.
One of them is a state jail, so if
Could I have the other case, please? I only have one. All right, the court is calling the 2025 CR 009798 and 2025 CR 007562C. All right, so their end cause number. You know what? Wait a minute, Norma. It's divided up weird. So I have part of this, but I don't have the docket sheet or anything for it. So there's some missing pages. I don't have the, yes. I don't have the admonishments on this. That's the one.
do you need us to step back, Judge?
Oh, no, just give us a moment.
Judge, can you mic on?
Yes. All right. Thank you. Oh, and on this one, do you have a docket sheet? Thank you. All right. So, and cause number, could you all move? Because y'all are blocking Vashon, and sometimes if you can't see, you can't hear. At least that's how it is for me. So in 2025 CR 009798, there's a $1,500 fine probated, 3 years deferred adjudication. It's a run concurrent with 2025 CR 007562C. There's to be no residing with.
This is where it gets even heavier. The court stacks conditions like parenting classes, community service, and random drug tests. This isn't just about punishment, this is about transformation. But here's the big question. Do these long probation deals actually work, or do they just set people up to fail? Sound off in the comments.
Layla Aguero, and no unsupervised contact with Layla Aguero until the defendant tests negative.
And Judge, is that negative for the marijuana, or do you want him off the methadone as well?
The methadone, that doctors will have to do that. But what I can tell you with methadone, that's not technically supposed to be
Getting
down.
of it, yeah.
All right. So the levels on that needs to start going down.
Yes, ma'am.
All right. There's to be regular reporting by Zoom or in person, regular random UAs. $100 of community service restitution. I'm going to order parenting classes. Once the parenting classes are complete, the community service hours will be deemed satisfied. Field visits 1 time per month until further notice. And that cause number, did you review the trial court certification of defendant's rights to appeal with your attorney? Did you understand it and sign it?
I did, Your Honor.
Because this plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. And cause number 2025 CR 007562C, the court will sentence you to 6 years deferred adjudication. There's to be a $2,000 fine. That will be probated. There's to be restitution of $380 to the Bexar County Crime Lab for drug testing. $200 hours of community service restitution. I'm going to order the MRT. Once that's completed, 100 hours will be deemed satisfied. And I'm going to order the life skills course. Once that's completed, the remaining 100 hours will be deemed satisfied. There's to be regular reporting by Zoom or in person, regular random UAs, field visits until further notice, 1 time per month. There's to be no residing with Layla Aguero and no unsupervised contact with Layla Aguero until you present with a negative UA.
And there it is. Final blow. 0 contact with the child until he tests clean. Imagine hearing that about your own kid. Do you think that's fair? Or should supervised visits be allowed no matter what? Let's hear your take.
Probation in either of those cases. Is there anything else?
Employment, sir.
All right, thank you. Proof of employment. And each cause number, there is to be proof of employment within 30 days, no employment as a home health care provider or with minors.
So that I'm fully aware in regards to the methadone, are you saying non-supervised contact until negative from the marijuana, anything else other than that methadone, or?
No, it should just be, he shouldn't be positive for anything except methadone. Thank you. And that cause number, did you review the trial court certification of defendant's rights to appeal with your attorney? Did you understand it and sign it?
Yes, Your Honor.
Because this plea bargain agreement in that cause number, because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, Your Honor.
All right, we can go off the record. Here's the thing. Your child is 100% dependent upon you. She can't go in Travis Park and make it on her own. She's 100% dependent on you and your wife. If any of you fall down on the job, then she's just out there alone by herself. You understand?
I do, Your Honor.
So you're going to have to start doing better, and doing drugs is not good. All right.
Yes, Your Honor.
In this court, communication is key. If there's an issue, let your probation officer know. If you feel they're not addressing it, you can always come to the court.
Yes,
All right,
Your
good
Honor.
luck to you.
Thank you,
Thank
Judge.
you.
May we be excused?
Yes. Hello, good morning. How are you doing?
Doing all right?
Thank you for dressing appropriately for court.
Yes, ma'am. Thank you.
All right, the court is calling 2025 CR 009749 State versus Cullen O'Neill. Could I have parties announced?
Stephen Spear for the state.
Brian Kimbrough from Mr. O'Neill.
And are you Mr. O'Neill?
Yes, ma'am.
Counsel, have you received all discovery?
Yes, Your Honor.
Did you review it with your client?
Yes, I did.
Court will find that the state is in compliance with discovery. Mr. O'Neill, did you review the application for deferred adjudication with your attorney? Did you understand it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
I did.
State, are you proceeding on the indictment as presented?
We are, Your Honor.
All right. Did you review the admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
All right. You're charged with online solicitation of a minor sexual conduct. That's a second-degree felony. Range punishment is anywhere from 2 to 20 years in prison and up to $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Do you understand?
Listen closely. This man just waived his right to a jury trial in a case involving online solicitation of a minor. That's a second-degree felony with up to 20 years behind bars. Would you ever give up a jury for a judge in a case this serious? Yes or no, and why?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call in the right to remain silent. By entering this plea, you are giving up those rights. Did you intend to give up those rights and enter until? Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 20 years in the prison and up to $10,000 fine?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do.
Mr. O'Neill, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Did you understand if you're not a U.S. citizen, by entering this plea, you can be deported, not allowed re-entry into the United States, and denied naturalization?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at a cap of 8 years in the prison. There's a $3,000 fine. The state is opposed to your application for community supervision. And there is to be Chapter 62 compliance. And the state is reserving the right to request specific conditions if your community supervision were granted. Did you understand that to be the plea?
Yes, ma'am.
We had, agreed to, with the state, to leave the fine open to the court, the amount.
All right. So any objections to the court? This is what I can tell both parties. No one knows where these fines go when they're collected. Usually unless there's a reason why I shouldn't, normally I probate the fine. So is there any objections to the court probating, writing that as a part of the agreement to probate the fine?
Since that's the court's practice, that's fine by the state.
That's fine, Judge.
All right. But sometimes if the state will present an argument as to why that fine should be in place, I would do it. So I can either just write probated on it, or I can put it below the line.
Below the line is probably better, Judge.
All right. So what I'm going to do is I'll put it below the line. Is there any objections to the court doing that?
No objection. That's what we kind of anticipated.
Exactly.
Okay.
Thank you, Judge.
Oh, no problem. All right. If y'all would like to initial that. So other than those changes, did everyone understand that to be the plea bargain agreement?
Yes, Your Honor.
And counsel, is that the plea bargain agreement?
It is.
And Mr. O'Neill, do you understand that the only change in your plea bargain agreement is that your attorney wants to argue for not imposing the $3,000 fine or arguing for something less than the $3,000 fine?
Right.
All right. Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
Did you understand by signing that you waive?
Now this part is wild. The whole argument boils down to a $3,000 fine. Think about it. A man facing decades in prison is now worried about the money part. Should fines even matter in a case like this? Or is the real punishment all about time and restrictions?
Your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court.
Yes, ma'am.
Counsel, are there any such motions?
No, Your Honor.
Outside the agreement, the state is requesting that there be a $3,000 fine. Did you understand that's a recommendation from the state and the court does not have to follow that recommendation?
Yes, ma'am.
All right, then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence?
Yes, Your Honor. At this time, the state would offer State's Exhibit Number 1 and its attachments.
No objection.
All right, did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments, and the court will review the same. All right. After reviewing State's Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. So, counsel, do you want a full PSI? If you want a full PSI, it will be probably 8 to 12 weeks. Or if you want to just have time to have witnesses come on your client's behalf, and I'll ask the state what his criminal history is, and then I'll make my ruling based upon whatever evidence is presented.
I think a full PSI.
All right, Norm, I need a date for PSI and TAP. And does there need to be a mental health evaluation or no?
No.
Okay. All right. So we'll come back on October 21st. Make sure you make all of your appointments with probation. There's a date for your PSI and there's a separate date for the TAP evaluation. Don't miss any of those dates.
Yes,
If
ma'am.
you're confused over, did I already do that? Did I not do that? You need to pick up the phone and call. You understand?
Yes, ma'am.
All right. Ms. Ferguson will give you a reset form. Once you sign that, you're excused, and then you'll need to talk with probation and she'll tell you what you need to do.
Okay.
Thank you.
Thank you.
And the case closes with a full PSI ordered. Basically, the judge wants a deep dive into this guy's life before making the final call. It's like saying, we're not done yet. What do you think? Should every serious case require a full background report? Or is that just dragging things out?